What happens when an ex-spouse and a current spouse both claim to be the spouse for an irrevocable family trust? Here's the problem. One word. Spouse. The mother-in-law's irrevocable trust included her son's spouse as a beneficiary, but never used the word current, never used the word former, and only named her daughter-in-law as a backup trustee. After the son divorced and remarried, his mother, the grantor, died. And suddenly two people, an ex-wife from a 30-year marriage and a current wife in a 3-year marriage, both claimed the same beneficiary status as spouse. When does a trust beneficiary status become a specific person? When it's written or when it's distributed? And is divorce enough to disqualify an ex-spouse in an irrevocable family trust? The Texas Court of Appeals had to decide what one word, spouse, meant in the Ochse case. If you work with blended families who have estate plans written before divorce or remarriage, the Ochse results affect your client files, not just this family. In episode 112, ex-wife number 1 versus current wife number 2, who's the spouse for the irrevocable trust, we examine how one word pulled two people into the same beneficiary status, explore what determined whether a spouse is a person or a status, and analyze the appellate court's reasoning whether divorce and remarriage rewrite a mother-in-law's irrevocable trust. Join us to see how it litigated, and subscribe so you don't miss an episode.
When fortunes collide with courtrooms, wealth managers, financial advisors, accountants, fiduciaries, and lawyers need real answers. Welcome to Wealth Litigated, where Professor Kelly Lease Murray, JD, lawyer, legal scholar, and retired Vanderbilt Law faculty, analyzes actual courtroom wins and losses in asset protection to deliver actionable insights that optimize your client's wealth outcomes. From explosive family feuds over fortunes to sophisticated financial fraud, each week we explore what worked to protect wealth and what exactly went wrong so you get it right. And now, here's your host, Professor Kelly Lease Murray.
I'm Kelly Lease Murray, and this is Wealth Litigated, delivering all the drama of true crime without the blood. We break down actual court cases that impact your professional practice and your client's wealth outcomes. Let's gavel in. Ochse is a 2020 Texas Court of Appeals decision that asks a simple question: who's the spouse for purposes of the mother-in-law's irrevocable trust? Before we get into the case, think about this. How many of your clients have been divorced and are either in a second or third marriage or contemplating getting remarried? If existing irrevocable trust documents name a beneficiary's spouse as merely spouse, which spouse is it? Is it the beneficiary's spouse at the time the trust was signed? Or is it the spouse at the time of distribution? The Ochse decision is unpublished, which means it's not precedential. Something else to keep in mind is the appellate standard of review. The trial court granted one party's motion for summary judgment and denied the other party's motion for summary judgment, which means on appeal, the appellate court reviewed the dispute de novo, and that simply means stepping into the shoes of the trial court. There's no deference to the trial court. Presents a definition problem, but also a client file problem. For all of those irrevocable trusts that your clients are either the grantor for or the beneficiary of, if the term spouse is used without identifying a specific person or a specific point in time to identify who qualifies as the spouse, that's a practice problem waiting to happen for your clients, which means your risk radar should be ringing right now. Let's have a look at the stakeholders, answering the key question: which spouse when? The trust was created in 2008. It's actually named after the grantor's son. He's the primary beneficiary, and in 2008, he had been married for decades to his first wife, and they had 2 children. At the time the grantor passed away, he had been divorced from his first wife and was at that time remarried to his second spouse. For purposes of the irrevocable trust, who is the primary beneficiary's spouse? Here's the primary question. If the trial court locks in the identity of spouse as of 2008, that means the ex-wife is the beneficiary, the primary beneficiary's spouse, even though they had been divorced and he had been remarried for 3 years. If that's the result, wife number 2 is frozen out, and the son, who's also the trustee in addition to being the primary beneficiary, will have to face his current wife, explaining that he has to pay distributions from the trust to his ex-wife as his spouse for purposes of his mother's irrevocable trust. The roadmap for this irrevocable trust. The parties include the grantor, the son's mother, but from the perspective of spouse number 1 and spouse number 2, we will refer to her mostly as the mother-in-law. The mother-in-law is the grantor, the primary beneficiary is her son, additional beneficiaries are her 2 grandchildren by her son and his first wife, and then another beneficiary is the primary beneficiary's spouse. When the trust identifies the trustees, it uses names, not descriptions. The son is named as the trustee, and the successor trustee is named, and that name is the name of spouse number 1. The trust was irrevocable when it was signed. That may not always be the case with your clients. The trust could be revocable and becomes irrevocable upon the death of the grantor. But here in 2008, it was irrevocable from the start. The trial court ruled on 2 summary judgment motions. On one side is the son and wife number 2. On the other side is wife number 1. The trial court granted one motion and denied the other. Here's the timeline, which gives us, in addition to the result at the trial level, the procedural history. I didn't start with the procedural history because, interestingly, the beneficiaries who started this litigation are absent from the appeal that we're looking at. The trust created in 2008. In 2012, the son and his first wife divorce. In 2015, he remarries. In 2018, his adult children sue the son, their father, for breach of fiduciary duty as the trustee. And they join their mother, wife number 1, ex-wife of the son, as an interested party. That's how wife number 1 enters the litigation. 3 weeks after that litigation started, the grantor died. Wife number 2 intervened. The intervention by wife number 2 was technically a declaratory judgment asking the court to identify her, wife number 2, his current spouse, as the beneficiary under this irrevocable trust. Even though the 2 adult children started the litigation, they were not involved in the summary judgment motions and they were not involved in the appeal. Ultimately, the trial court ruled that wife number 1 was the beneficiary because it was fixed at the time the irrevocable trust was signed. And the trial court denied wife number 2's summary judgment motion because it had ruled the term spouse was a person and not a status. Let's have a look at the actual clauses included in the mother-in-law's irrevocable trust for the benefit of her son's descendants, and her son's spouse. What do you think that means? Does that mean her son's spouse in 2008 at the time the mother-in-law signed this trust? Or does it mean at the time the trust is distributed? Because at that later time, he has been divorced and remarried for 3 years. In a different section, to the primary beneficiary's descendants, and the primary beneficiary's spouse. Everyone agreed both of these labels applied to the same person. What they disagreed with is who that person was. This argument of naming asymmetry translated when the irrevocable trust signed by the mother-in-law identified who was a beneficiary. She did not use anyone's name. She wrote her son, his descendants, his spouse. In that same trust instrument, when the trust was identifying the trustee, a person was named. The son was named, his first name and his last name. When the successor trustee was named, a person was named. Wife number 1, her first name and her last name. Each side argued that meant they prevailed. For the son and his second wife, they argued that if the grantor had meant for the primary beneficiary's spouse to mean wife number 1, they could have used the name of wife number 1 because they used it separately, her actual name, as the successor trustee. On the other side, wife number 1 argued that she and the son were not named when they were identified as beneficiaries. It was the descriptive primary beneficiary and primary beneficiary spouse for purposes of beneficiary identification, and then as trustees, each was specifically named. Ultimately, the pattern is name where you administer, relationship where you give. It supported both sides. How did the appellate court rule? We know the trial court ruled in favor of wife number one, but does wife number one get affirmed on appeal, or is it reversed? Appellants were the son and his current wife, wife number two. They have 4 textual arguments. The first is the asymmetry we just looked at. Class language. They were arguing that spouse is a class, not a specific person. If they're correct, then spouse is identified at the time of the distribution and not locked in 2008. Another argument they made is powers of appointment. The son was granted testamentary powers of appointment. And the phrasing used was similar to a SLAT, a spousal lifetime access trust, and that floating spouse concept, which would lean towards identifying the spouse at the time of distribution. Who is he married to at the time his mother died? That would be spouse number 2. And they had one more argument. In 2008, the mother-in-law did not have a husband. Because the trust includes the term husband, her son and wife number 2 argued that evidenced the intent to use status through labels like husband and spouse. Appellee had similar arguments cutting the other way. Her strongest argument was simply that Texas's default is the spouse at the time the trust is signed. If she's right, she not only won at the trial level, she'll win on appeal. Another core argument for wife number 1 on appeal was spouse as a class. A gift to a class requires an uncertain number, and in 2008, it wasn't uncertain. At the time this 2008 irrevocable trust was signed, there was only one spouse for the primary beneficiary, and she was that spouse. Which do you think prevails on appeal? And which should have prevailed on appeal? My son's spouse locked in 2008 at the time the mother-in-law signs the irrevocable trust? Or my son's spouse at the time of distribution open until distribution, which would be wife number 2? Before we answer the appellate question in Ochse, we're going to look back at episode 107, the Dahl case. Dahl had the opposite result compared to Ochse at the trial level. Ochse at the trial level ruled in favor of the spouse at the time the trust was signed. In Dahl, by contrast, this is a Utah divorce interpreting a Nevada irrevocable trust. There are definitely different facts between the types of trusts and who the grantor was. In Dahl, it was the husband who had created these irrevocable trusts, named himself as the sole grantor, the sole settlor, and the beneficiary was labeled settlor spouse. In Dahl, the ultimate result at the Utah Supreme Court was that the wife lost her status as settlor spouse upon divorce and was not a beneficiary of the irrevocable trust. Well, that's the opposite of the trial level result in Ochse. Same word. Settlor spouse, primary beneficiary spouse. There's no difference in the word spouse. So why was there a totally different outcome when you compare Utah and its appellate result with the Ochse trial result? You and your clients need to know how this litigates in your state. You need to know the phrasing that was analyzed. You need to know what is the state default, and you need to know the outcomes, which brings us back to Ochse. Is primary beneficiary's spouse a person? That means it's wife number 1 as of 2008, or is it a status which would make that person spouse number 2 at the time of distribution? How do you think it turned out? How do you think it should have turned out? Ochse was affirmed on appeal. It's the opposite result of Dahl, spelled D-A-H-L, in Utah. The Texas Court of Appeals affirmed summary judgment in favor of wife number 1, confirming that the spouse was identifiable and in fact identified as of 2008 when the irrevocable trust was signed by the grantor, son's mother. Because wife number 1 was locked in 2008, wife number 2 was frozen out. Litigated outcomes are your guardrails for wealth protection. Without them, you and your clients are flying blind. And there's one phrase that could flip this case, and that would be, my son's spouse at the time of distribution. Well, the distribution didn't occur in 2008. Who is the spouse at the time of distribution? Wife number 2. If the mother-in-law's irrevocable trust had identified primary beneficiary spouse at the time of distribution, the result is the opposite, and they may not even needed to have litigated. That would have been clear, specific, and within the four corners of the document analysis conducted in the Ochse appellate decision, that would have held up. The appellate court's reasoning. We're going to spend a little bit of time on this. The first is pointing out that Texas has a default, and the default is unless you are specific in identifying a spouse in the trust, the default in Texas is the person identifiable at the time the trust is signed. Ultimately, the Texas appellate court held that appellant's arguments were inconsistent with Texas precedent. Under the Four Corners rule, this is the canons of construction, and the court pointed out it's the same review whether the document is a will or a trust. First, the court has to look at the actual words used. If they're not ambiguous, that's it. Just use those words and their plain meaning, and then harmonize all of the provisions. The appellate court held that the asymmetry, naming the son and his wife number 1 as trustee and successor trustee, actually cuts against wife number 2's argument, pointing out that son and wife number 1 were treated exactly the same way. And if the son is still primary beneficiary, then wife number 1 is still primary beneficiary spouse for purposes of the trust. But the arguments raised by appellants, that would be the son and wife number 2, they might work in a different state. The class gift, we already talked about this reason. It's simply that a class is usually an unidentifiable number at the time the trust is created, like to my primary beneficiary's descendants. Well, there could be additional descendants, whereas a spouse is identifiable at the time of signing. The husband distinction, that the grantor did not have a husband at the time she signed the irrevocable trust, did not make it a status. We're going to have a look at the paragraph, footnote 1. Despite our interpretation of the trust in wife number 1's favor, we disagree with her argument that because the trust is irrevocable, her right as a beneficiary vested upon the trust's effective date in 2008. The principle of irrevocability is inapposite. An irrevocable trust simply means that a trust whose terms cannot be changed by the settlor once the property is conveyed to the trust. Let's translate. Wife number 1 used this as an additional argument. She already prevailed under other grounds. Because of that, the appellate court's rejection of this argument didn't change the outcome, but it's interesting and worth a post-it because of the reasoning here. The appellate court points out that irrevocability has nothing to do with the four corners of the document is spouse identifiable as of the signing of this trust, whether it was revocable or irrevocable. But your clients, by contrast, may have a trust that is revocable at the time it's signed. If the phrasing concerning the beneficiary spouse includes an additional clause like primary beneficiary spouse at the time of distribution, that will have the opposite result for that client with that phrasing and those facts. Where the appellate court's reasoning is less solid. The husband distinction. The mother-in-law did not have a husband at the time she signed the irrevocable trust. That looks more like using these terms as a status. Husband as a status, spouse as a status. If the term husband was used as a status, that actually supports appellant's arguments that they lost on appeal, but it would have supported their argument that primary beneficiary spouse was a status, just like the use of husband was a status, given the grantor did not have a husband at the time she signed the irrevocable trust. The word class is used in this agreement, and the appellate court doesn't fully resolve that ambiguity. Another point is the at any time, from time to time, in all events. This mirrors the floating spouse concept of a SLAT, spousal lifetime access trust. If you use the term floating spouse, include that specific point in time. Does the grantor want the spouse to be identified at the time of distribution? If so, it's probably a good idea to add a clause, and that the asymmetry cuts both ways, because the drafter of the irrevocable trust that the grantor signed in 2008 could easily have identified wife number 1 by her name as the beneficiary. Compare all of this to the Dahl result in Utah, DAHL. The settlor in Dahl was the husband, and divorce divested his wife of her beneficiary status because she was no longer married to the settlor. That's the opposite result from Ochse. Back to that blended family consequence, imagine the son. He's the primary beneficiary. He's also the trustee who now has to pay his ex-wife as primary beneficiary's spouse under his mother's trust, because his current wife, wife number 2, is frozen out, which makes Ochse a wake-up call. Not that this is actually going to be precedential for your clients in any state. It's not even precedential in Texas. But the facts may be similar, and the arguments were strong on both sides. In other states, this could be more of a coin flip. How does that shake out for your clients? You may need to get in touch with the clients if they have since divorced and remarried or are considering getting remarried. Who's the spouse? Does the trust specify? That's the wake-up call. 2 counterfactuals. Counterfactual A is a drafting fix. Anchor the spouse to a moment. Be specific. Primary beneficiary spouse as of 2008, as of the signing of this trust, or simply name the spouse, so primary beneficiary spouse, and then use the name. Or lean into that floating spouse concept. When a beneficiary spouse is also a beneficiary, name the person or name the moment in time that spouse status is measured. Hypothetical B, instrument fix. What if this trust had been revocable in 2008? It wasn't, but what if it had been revocable in 2008 and became irrevocable at the time of the grantor's death in 2018? The Texas court in Ochse held it wouldn't have made a difference, but in other states it might, because the status changes if no one is a beneficiary until it becomes irrevocable. In other states, all the beneficiaries' status is evaluated at the time a revocable trust becomes irrevocable. So when does the spouse clause lock? It depends on your state. It depends on the 4 corners of the trust agreement. It depends on your facts. Factors stacked in Ochse. First, Texas and the Texas default. Second, the spouse on signing day was identifiable, so it was not an unquantifiable class at that point in time. The bare word spouse had no qualifier, and the 4 corners rule prevented ambiguity analysis. The words were interpreted as they were objectively written, not looking for subjectivity. What did the mother-in-law really mean? What does wife number 1 get as primary beneficiary spouse under the irrevocable trust years after she and the son divorced? HEMS, health, education, maintenance, and support. And the trustee who has to make those payments to his ex-wife is the son as the trustee. And if he declines to serve as the trustee, the successor trustee is still his ex-wife, wife number 1. When you pull client files this week, the first issue to look for is this. Is the former spouse named as a successor trustee without a divorce trigger removal clause? That's something your clients need to know now. You may have clients who are the parents or grandparents of adult children, adult grandchildren, who may be married, who may have been divorced and remarried. Who's the spouse based on the trust documents? An additional issue is which state's law governs the trust and where do the beneficiaries live? We looked at this in episode 111, the Jones case, where the trust was governed by Michigan law and the divorce occurred in Massachusetts. That makes a difference. Our takeaways focus on spouse beneficiary drafting options. When you're looking at client files, look for these. My son's spouse named. That is much less likely to be considered a status and much more likely to identify a person. Trusts may not have their beneficiary status revoked even with a divorce. Is the ex-spouse supposed to inherit my son's spouse at the time of each distribution? That is very specific. Stress test that with actually litigated cases in your state. That floating spouse concept used in SLATs, spousal lifetime access trusts. With that, the son and wife number 2 would have prevailed. Put a post-it on this next one. Automatic removal upon divorce. That needs to be written into the trust. It's not going to happen by operation of law. Do you have clients who are divorced, whose former spouses may still be the beneficiary? Your client needs to know. And then remarriage protection Is that an unintended benefit? Client conversations you should have this week. Pulled client files based on the factors and facts we've talked about, reviewing the language and the facts and the state that governs the trust and the state where the beneficiaries reside. Even though Ochse isn't precedential in Texas or any other state, this stark contrasting result from the Dahl case in Utah confirms that without knowing how these types of trusts actually litigate under similar facts in your state, you and your clients are flying blind. Before you tell a client, don't worry, your current spouse is covered under your parents' trust that was signed when you were married to your previous spouse, perhaps is not wealth protection. Instead, it may be wealth litigation. Thank you for joining us. Stay tuned for a preview of our next episode. What happens when a disinherited son turns the family's alleged estate tax fraud into a $20 million New York whistleblower case? This is People of New York, ex rel. Pressman v. Pressman, and the case is still litigating. Here's the problem. 1 out of 4 adult children of the famous Barney's New York family was disinherited from his mother's trust. But instead of getting nothing, he became the estate tax whistleblower. The estate may owe more than $20 million in New York income and estate tax revenue, and he could be paid more than $6 million instead of 0. Here's the allegation. 1 primary address: Florida or New York. The tax fraud complaint alleges the matriarch actually lived in the Hamptons during the final 6 years of her life. She filled prescriptions at a Southampton pharmacy. She had aides working there, but the family allegedly identified her primary residence as Florida, avoiding more than $20 million in New York income and estate tax. If your clients have residences in New York and other states, claiming the lower tax state as the primary residence, the Pressman case affects your client files, not just this family. In episode 113, $20 million whistleblower, heir disinherited from mother's trust sues estate for tax fraud, we examine how a disinherited son turned New York's False Claims Act into litigation revenge against his siblings and his mother's estate. Explore the domicile as fraud theory that could cost more than $20 million in tax liability plus penalties, and analyze the rare state qui tam framework that lets a private heir sue for tax fraud on behalf of the state. This is part 1 of Disinherited, a wealth litigated series on what happens when the plan to cut someone out ends up in court. Different families, different estate plans, different heirs who weren't supposed to win, but some still do. Join us to see how each litigated, and subscribe so you don't miss an episode.
This is Wealth Litigated, where the real courtroom battles we analyze today are your roadmap to stronger asset protection and better wealth outcomes. Follow us on your favorite podcast platform or subscribe on YouTube so you never miss a weekly episode. Questions or cases? Visit wealthlitigated.com/questions. This show is for informational and educational purposes only and does not constitute legal, tax, or financial advice. No attorney-client relationship is formed. Consult a qualified professional for advice specific to your situation and jurisdiction. Wealth Litigated is now adjourned.